To start with, I'd like to acknowledge the traditional owners of the land that I'm hosting this webinar on, which is the land of the Wurundjeri people of the Kulin Nations. I also acknowledge the traditional owners of the various lands you're all on, and any Aboriginal and Torres Strait Islander peoples participating today. I pay respects to their elders past, present and emerging, and the elders from other communities who may be here today. This acknowledgement is, of course, particularly poignant during National Reconciliation Week, and the theme, as you probably know, this year is Be Brave and Make Change. Taking action, being brave and making change on the path to reconciliation is not just limited to National Reconciliation Week, but this week serves an important reminder to us all to reflect, refocus and continue to listen and learn from First Nation peoples. Well, welcome everyone. So I'm John Hamill, CEO of the Essential Services Commission. Now, for those of you who aren't familiar with the Essential Services Commission and maybe here for the first time, we're the state's independent regulator of energy, water and local government, and some areas of transport as well. We also administer the Victorian Energy Upgrades Program. So the work that we're here to talk about tonight falls under our role as the energy regulator. I just did want to thank you all for joining our webinar on this final statement of expectations for land access. While we're aware of the protocols of online meetings and webinars by now, just as a friendly reminder, first of all, please let us know if you have a question or comment. And if you do have a question or comment, just simply send a message to the host and the panelists in the chat stating that you have one. This will ensure that everyone has a chance to have their say. You can also ask your question in the Q&A or chat functions at the bottom of your screen. I'll see the question and we'll ask if you'd like to speak directly to the group or have me read it out. You could also use the raise hand function if you'd like to speak directly to us. Also, please be aware this webinar is being recorded. We will post it online so people who were not able to attend can also review. I'd like to quickly introduce those from the Commission that we have here with us today. And if you could give us a wave when I introduce you, that would be great. So first we have Sarah Sheppard, who's our Executive Director of Energy. And we have Aaron Ewan, who's the Senior Regulatory Manager for Analysis and Reform, Mirren Wilson, who's the Manager of Reform Team, and Sukhmani, who's a Regulatory Analyst. I think Mirren and Sukhmani may be here, but they might also be sitting in the background. Also, thanks to Alex, who's been the coordinator for all of this behind the scenes to make sure that the webinar runs smoothly. Great, thanks everyone. And in terms of our focus today, we'll be looking at what the Statement of Expectations means for landowners, transmission companies, and what we expect in terms of reporting and compliance. We'll also discuss the next steps of this work, which is the development of an enforceable code of practice relating to land access. And work on that code will occur over the remainder of this year and will involve a significant amount of engagement in the coming months. However, we're keen to hear your thoughts tonight to help us start with this development. Land access for transmission companies is becoming an increasingly important issue as transmission companies build critical energy infrastructure to transition Victoria's power system to net zero emissions by 2050. However, with very few major Victorian transmission projects in recent decades, there have been little demand for codes of practice for land access such as this to establish parameters for the use of Section 93 powers. However, this has changed. Significant upgrades to Victoria's energy transmission grid are now necessary to facilitate the transition to net zero emissions by 2050. Strong community concerns have been raised about the use of Section 93 powers by AusNet services to access land to the Western Victorian Transmission Network project. As an enforceable instrument, a code of practice will be subject to our Charter of Consultation and will take approximately 6 to 12 months to develop. Given the number of concerns that have been raised, the anticipated increase of use of Section 93 powers for transmission investment to support renewables, and the time required to develop this code of practice, the Commission, we began developing the Statement of Expectations in January 2022. It's a targeted interim measure to address concerns quickly and efficiently during the intervening period until a full code of practice can be made. We do expect transmission companies will comply with the principles under the Statement of Expectations. It sets our expectations. It's not fully enforceable, but it is a precursor to an enforceable code of practice. However, failure to report on the performance against the statement of expectations would be a failure to comply with a condition of a licence, which is a civil penalty requirement. And we have various options for failures to comply with civil penalty requirements, including issuing a penalty notice. We want to ensure that companies undertaking this land access work consider the needs of local communities. In developing this statement, we listened to the concerns of a range of stakeholders. We considered early stakeholder feedback when creating the principles in the draft statement of expectations and refined these principles based on the feedback we received from stakeholder submissions and events. The principles in the final statement of expectations are a product of this feedback and consultation and best practice land access frameworks from other states and industries. Landowner and community interests are front of mind as we develop this statement. And I'd really like to thank everyone who participated in our consultation on this statement. We also wanted to assure that as we move into the development of the formal code, we involve all stakeholders in this process. I'm now going to hand over to Sarah, our Executive Director of Energy, who will provide a brief overview of the work. Thanks, Sarah.
Thanks, John, and good evening, everybody. I'm really happy to make this an interactive session. As I'm going through it, if you'd like to put comments in the chat or put up your hand, and we can just take questions and comments as you go along, or afterwards. John's happy to chair a Q&A session. So I do have a few slides. Alex, yeah, if we can just go to the second slide. So I wanted to start by talking about how we listened to people who have been impacted by land access by energy companies, and also how we heard from other people who have been involved in the process, such as AusNet staff who have carried out some of these land access visits. So as John mentioned, we've been consulting for a while now. We've engaged with landowners and of course their supporters, community groups, representatives. We've talked to staff from the licensed transmission companies, including AusNet. We've talked to EWOV, or it's the Energy and Water Ombudsman of Victoria, which we call EWOV. We've also talked to Mr. Andrew Dyer, who many of you know, who's the Commonwealth's Australian Energy Infrastructure Commissioner. We've spoken to a number of local councils, particularly in the Western Victorian region. And of course, we've spoken to the Department of Environment, Land, Water and Planning, which has an interest in this area. So in this process, we published a draft statement of expectations on Engage Victoria on the 24th of March. And we had quite a number of submissions to that. So we had 28 submissions. Then on the 4th of April, we had a public webinar. We had 36 people attend that. Then we had an industry forum to talk about the statement with industry. And then we met again with landowners and a couple of councils to further refine the statement. And of course, AusNet again towards the end of the process. So I'd like to turn to what we've heard so far about how land access has occurred in the region of the Western Victoria Transmission Network project, because that really is the key project where Section 93 powers have been used in recent times. So the first thing I would say is that some of the stories we heard from landowners and community groups really were distressing. So many residents told us they'd never even heard of the Western Victoria Transmission Network project when they received a letter seeking access to their properties. And I think this was around 2 years ago now. And so we heard that some of these landowners have really been greatly distressed about this project for that whole time. And we've heard how it's impacted on their families, their work, and their enjoyment of their land. We've heard about really fraught land access visits. We've heard about people feeling intimidated, unsafe, and powerless. And we know that there have been times when the police have been involved. As I mentioned at one of these last webinars, we've heard stories from landowners who really felt offended by the way that AusNet spoke to them about their land. And people who felt that AusNet just didn't understand the depth of their connection to their properties and its intergenerational significance to their families. We've also heard from landowners that some felt confused about who was in charge of this project, and that some stakeholders felt there was a real lack of transparency around the project and about who was trying to access their land. And we've also heard some scepticism about whether AusNet would comply with our statement of expectations. One comment that I think really stuck with me throughout this process was from a landowner who said that he felt as though AusNet saw him as an obstacle rather than a partner in the development of the project. So other concerns that we heard are outlined on this slide. So we heard concerns about unclear or even misleading communication. We heard about a lack of a clear complaint or dispute resolution process. We heard concerns about contractors who come out to land. We heard concerns about a lack of flexibility around when AusNet would come onto the land. As I mentioned, accountability issues, the lack of collaboration, and a lack of sensitivity in communications. And so one thing on this slide as well that's really important to point out is that we also heard from AusNet staff, and some really felt afraid when they were accessing land. And this was a key thing we heard, concerns about giving out their surnames or personal details in case they were targeted by either online or even in-person abuse. So turning to the next slide, what we wanted to do first is try not to reinvent the wheel. If there was some learnings out there from other jurisdictions that might help with this process. So this slide really sets out that we also reviewed the processes and guidelines in place in other jurisdictions to see what we can learn from them. And you can see here we've set out just a couple of them: the PowerLink, Land Access Protocol. I won't read them all out, but they're all available online if you're interested in going and having a look at them. And one of the really important things I think we learned from these guidelines is that best practice is to be principles-based rather than to be very prescriptive. And the more we went through this process, the more this resonated with us, because of the wide variety in differences between the circumstances of each of the landowners and wide variety of different uses of land. So perhaps, Alex, we'll just move to the next slide, just give an overview of the statement itself. So, as I said, we're using principles-based. So we've got 22 principles for land access. And then next to that, we have examples of actions that a transmission company should take to comply with each principle. And what we're trying to do here is to achieve a balance between the statutory right for these licensed electricity corporations to access private lands, because they do have this statutory right, and on the other hand, the rights of those interested in the land affected by that power. And really at the heart of it, what we're trying to do is promote effective engagement between landowners and parties interested in land and the electricity transmission companies. We're trying to promote the idea of there being a critical partnership here in the delivery of major energy projects. So there's two important things to mention on this slide, and that's about the scope. So the first part of this is that the scope is going to be limited to major transmission projects, greenfield sites relating to major transmission projects. We're not talking about maintenance of existing assets. And really, because this is because there's long-standing access arrangements in place, thousands of them, for more routine access visits, such as around tower inspections, vegetation management and maintenance. And a lot of these areas operate routinely without any complaint. So we thought to extend the benefits would be unlikely to outweigh the costs in that circumstance. And then the other question we had was about whether or not the statement should cover access where a landowner has entered into a voluntary agreement. Now, we were thinking a lot about this. I think on balance, we accepted that the vast majority, if not all the issues that have arisen that we've heard about, have been in circumstances where no agreement has been entered into. So on balance, we thought it was proportionate at this stage for the statement just to cover access visits where there has not been a voluntary agreement entered into. But we're really encouraging transmission companies to consider applying the principles under all access agreements, voluntary or not. And certainly if the type of access goes beyond the limits set out in a voluntary agreement, we would expect the statement of expectations to apply. So we'll just go into, this is a summary of the principles. And now I think Alex, just want to make sure everyone's got the actual principles available to them. So I think Alex has popped that into the chat. It's on our website. I'm pretty sure it's on Engage Victoria as well. It's in the chat now. And if you or your neighbours or anyone you know is having difficulty accessing a digital version of this, can you let us know and we'll mail you out a hard copy. I'm very happy to do that. So I'll just have a talk through of the principles and how this works and what challenges we hope they'll address. And just to clarify, we expect these principles to be applied as a minimum when an energy company accesses private land within the scope of the statement of expectation. They, of course, can go beyond it. So the first heading we've got here is around approach to communication and engagement. And this sets out the principles that companies should adopt when planning a project that will involve land access. And Vicky has made a very good point. Can you please also draw people's attention to the explanatory statement? That is a great idea, Vicky. Maybe, Alex, you could pop that in the chat as well, because we've gone through in a lot of detail what we've heard and how we came up with each of the principles. So in that first column there, approach to communication and engagement, I'm just going to pick an example to talk through in a bit more detail. So number 3, be accessible and responsive. So this addresses a concern that we heard a number of times throughout the consultation, that they would have multiple different land liaison officers, or the person that they thought they were dealing with would change, or they just didn't know who to get into contact with if, say, it was a weekend, they had a visit scheduled for Monday and something had happened, which meant that perhaps the visit couldn't go ahead, or they'd need some flexibility in changing the time of the visit. So what this means in practice is that we would expect that there would always be someone available for a landowner to speak to, whenever that is. So it could be on the weekend, after hours. We always want someone to be available. So how we worded this in the statement itself is we're saying an electricity transmission company will provide affected landowners with an accessible point of contact within the company. They will be available to respond to questions and address issues promptly during all stages of a transmission project. So the second heading here is process of communication and engagement. And this is really about the principles that transmission companies should adopt before, during, and after accessing land. So I'm just going to talk through one of them, which was which was a tricky one. So I'm going to talk about 7, which is provide identification on contact. So really, this principle was really just designed to ensure that landowners know who is accessing their land, have a bit of transparency over it. Now, this one was surprisingly contentious in that we received feedback that some employees of AusNet were reluctant to provide their surnames or any identifying details, really, in case that meant that they would be targeted online or even in person. Now, we haven't investigated, any of these claims, and obviously they would not be matters for us, they'd be police matters. But we've made it clear in our statement of expectations that it would be absolutely unacceptable for any party involved in land access to ever engage in conduct that might intimidate or threaten the physical safety of another. So while this was a tricky one, for now, while trust is really so low between the parties, we have not mandated that surnames of the land liaison officers be disclosed. But it is my strong hope, and indeed it is my strong expectation, that over time the hostilities between parties will dissipate and engagement will resume in a more respectful manner. So how we have framed this expectation is: an electricity transmission company will ensure that anyone contacting landowners regarding land access, whether by phone or in writing, from or on behalf of the electricity transmission company, will clearly identify themselves and who they work for and specify the purpose of the contact. The electricity transmission company need not disclose the full names of individuals acting for or on its behalf, provided that the individual has identification or written authorisation that a landowner can readily verify with the electricity transmission company. The third heading is around managing the impacts of access. So in this section, we set out the principles that transmission companies should adopt to minimise any damage to the land, infrastructure, plants, livestock, and people when access occurs. And I might just talk through 18 because this was also a controversial and difficult one. Implementing environmental and biosecurity controls. So this was one where we considered that the prescriptive rules around specific biosecurity measures that should be followed would probably not be appropriate. And this goes back to the significant differences between the landowners and the use of land in different properties. So we decided to have a more general principles-based statement on this one. So we've said an electricity transmission company will take all reasonable actions to ensure that in accessing land, it does not spread weeds, pests, or pathogens. They will consult with landowners to understand property-specific needs and provide details of environmental and biosecurity policies and plans on request. So with this one, I want to stress that engagement is necessary from the landowner as well. It is important for the landowner to provide AusNet or any electricity company with details of their biosecurity requirements and not request unnecessary biosecurity measures. So the final heading is managing disputes effectively and fairly. And in this section, we set out the principles that should be applied in the event of a complaint or a dispute. So we're clearly setting out here that there's 2 processes. Firstly, a clear internal complaints handling process within AusNet or another transmission company. And secondly, a robust third-party dispute resolution process. So I might, on that note, then turn to the next slide, unless there's questions anyone has that anyone wants to talk about. Let me just have a quick look at the chat. All right, I'll keep going and we can go back to those questions at the end. So this is a slide about dispute resolution. So as many of you, and I've spoken to many of you in this room, know EWOV, so this is the Energy and Water Ombudsman of Victoria, has jurisdiction already to hear complaints about the use of Section 93 of the Electricity Industry Act, which is the land access section. So, look, during our consultation, we were concerned to hear that some stakeholders did not think that EWOV was effectively resolving disputes relating to Section 93. And we heard a number of other suggestions about alternative bodies that could be responsible for dispute resolution in this context. So we took these concerns seriously, and we've met a number of times with EWOV to understand more about their processes and practices regarding complaints regarding Section 93. And look, on balance, we're not convinced at this stage that the benefits of moving the independent dispute resolution role away from EWOV and to another third party would outweigh the costs. And instead, what we're doing is we've been working closely with EWOV to increase their capacity to deal with these complaints. And in particular, we held a training session for EWOV staff about our statement of expectations late last week. And in addition, we're working with EWOV to explore the appointment of an expert panel who will support their handling of these complaints. And EWOV will have more to say about this in the coming weeks. And in the interim for tonight, EWOV asked me to provide you with some more information about their role, and you can see that on this slide. So I'd really stress that EWOV is independent and impartial. They look at the facts and individual circumstances of every complaint to make a fair and reasonable decision to resolve the issue as quickly as possible. EWOV is free to Victorian consumers, so you don't need to pay. And to make a complaint, I've just put some information there. I think someone's popped in the chat a question about it. Lisa, is EWOV appropriate? Why not VCAT, like other regulatory frameworks? Land access under mining legislation is to VCAT. So it's a good question, Lisa, and certainly we did think a lot about this one. The reason that we are sticking with EWOV in relation to this statement of expectations is because there is already a regime that is in place that sets up EWOV's jurisdiction, and to set up a party like VCAT to be a reviewer would take legislation or regulation, which wasn't available at this stage. However, we're happy to see how the process works, and as we're going through the code of conduct process, we're happy to relook at dispute resolution and see whether it has worked. I do feel that the expert panel is going to be a significant improvement, but I'm really happy to talk to you as we go along about what you're seeing from EWOV. So Alex, I might move on to slide 8. So one of the key issues that we heard about was the lack of reporting and transparency around the use of Section 93. So as John mentioned at the outset of this session, we have written to AusNet and required them to report as a condition of their licence with us on their compliance with the statement of expectations. So set out on this slide is what we will be requiring AusNet to report on. So we're asking them to report, requiring them to report both on voluntary access agreements as well as Section 93s. And we split it into categories around how the principles were applied. So principles 2 to 14 are essentially about communication and engagement before an access visit occurs. And then the principles 15 to 20 are essentially around minimising damage and dispute resolution. So you can see we've separated those out. We've also included in this the number and nature of complaints received, including those received by EWOV. And we'll be taking all of this information into account in developing the code of practice. And also, to increase transparency, we will redact confidential information from these reports and then publish them on our website. Now, the first one we've agreed with AusNet will be in August, and that will cover both June and July data. And that will provide time for the Commission and AusNet to agree an appropriate format for the report. So I might just move to the last slide. This is in terms of what's next. So the statement of expectations comes into effect on Wednesday. And I would mention that myself and my staff have been discussing the statement of expectations with AusNet and provided some training to AusNet staff on the statement of expectations. Then very soon we will commence work on the development of the code of practice regarding the Section 93 powers. Then in early August, we'll receive that first public report from AusNet covering land access during June and July, and we'll publish that. Then in the remainder of this year and early next year, we'll progress work on the code of practice and obviously do a draft so that everyone can see what we're proposing, and we can go through all of the issues that have been, that people are concerned about during this process. We'll address in that process, and the code of practice will commence in mid-2023. So that is pretty much all I was going to go through. And probably, Alex, you can probably take the chat away, and we can, actually, I might turn back to John now to, we can go through the Q&As. So I might let John do that, and then I can actually now go into the chat and read what people have been saying properly while I've been talking. Thanks, John.
I will mute myself properly this time. Yeah, thanks, Sarah. So now it's time for your time, and so I'd like to open up for discussion and hear from you. So if you have any questions, please feel free to put it in the chat or raise your hand. And if we can't answer your question now, we'll take it on notice and either provide an answer in the summary email or on our website when we post the video to the event. But we've already had a couple of questions, so I might just start with those. And those are questions that we were submitted before the event via our survey. So the first one's from Gerald, and he asks, we have jumped the process of consultation and gone straight to land surveys. When and how does this process address the social licensing of the landowners and protection of their property? So, Gerald, the answer to that is in Victoria, we haven't had existing regulatory instruments that outline how transmission companies should access land under Section 93 until we put out the statement of expectations. So really the land access for the Western Victoria Transmission Network project has highlighted that we think people would benefit from this instrument, and particularly the reporting that we're talking about, which will then build into how we do the code of practice and what we learned from this exercise. So we've done this consultation that we've talked about on the statement of expectations to learn, really better understand people's concerns and experiences involved in land access arrangements. And the final statement basically reflects that feedback and has been informed by understanding, as Sarah has gone through in quite a lot of detail this evening, of what best practice land access frameworks operate in other jurisdictions. So really, we're really doing this to promote effective engagement between landowners and transmission companies as critical partners in the delivery of those major projects. And what we're doing is trying to balance the rights of landowners with the statutory right of transmission companies to access the land by establishing these clear expectations. So as we've said, it's an interim measure, and it is intended to provide clarity and confidence for all parties, but it's also a mechanism that will enable us to learn as we go through the process from here on, and as we develop the formal code of practice itself, and through that formal reporting that we've talked about. So hopefully that gives you a bit of a recap on the answer to that. I've got another question from Anne, who has stud cattle, including bulls, and asks, what if I'm not present when AusNet want to enter my property, and what rights do I have to enforce strict biosecurity? So the answer to that one, I think as Sarah was talking about, is around Principle 18, which details our expectations around environmental and biosecurity controls, and transmission companies will be required to report on this measure. So Principle 18, as you recall, Sarah talked about it a bit in the presentation, states that an electricity transmission company will take all reasonable actions to ensure that an asset accessing land doesn't spread weeds, wastes, pests or pathogens, and they will consult with landowners to understand property-specific needs, including any relevant biosecurity plans, and will provide details of its own environmental and biosecurity policies and plans on request. So example of this are implementing systems to check for biosecurity incidents or outbreaks in the area prior to accessing property, and comply with any statutory limitations on movements, such as arising from incidents or outbreaks, adopting some come clean, leave clean practices, and observing biosecurity signage on properties. So I guess the main message out of there is what we've said is really, it's important that all landowners, if you've got something like bulls or cattle, really work with AusNet or the transmission company on your specific biosecurity plans. Make sure that they're aware of them, they know them, and preferably, I would have thought, agree with them how they're going to comply if you're not on the property, and also how they might report on or show you that they've complied as well. Might be a worth having a discussion too. So that's hopefully that gives you a bit of a sense of what we're trying to achieve through the biosecurity work. And as Sarah was saying, we didn't want to be too prescriptive because there's so many complex issues in this space, and some of them need to be customised in the particular landowners or reflect particular land needs. We have another question. I don't think I've got a name, or maybe it's another one from Anne. I think it might be a question too from Anne, actually. I'm not quite sure. Who is responsible for AusNet employees' safety and my animal safety when AusNet have entered without permission? Anytime a transmission company accesses a property using the powers under Section 93 of the Electricity Act, it must comply with its statutory obligations under that section. And transmission companies, like owners, must also comply with existing laws and regulations relating to personal livestock and property safety. So I guess that answer is they're obliged to comply with all existing laws around personal livestock and property safety when they're on your land. So I think that's all the pre-existing questions. Now, what do we have? I think we have a question, don't we? Alex said, someone has said in the chat, I have heard from many members that there are a few access arrangements in place and they're not given, and that people are not given the opportunity to comment or seek changes when there have been changes in regulatory issues since the infrastructure was in place. Should we report those issues to ESC or Ombudsman? Look, I think the principles around these sorts of things should be the best first option is to raise your concerns about a change in regulatory issues would be to raise them directly with AusNet. The second point of call is if there's a disagreement with AusNet about that, then I would have thought the first port of call would be with EWOV in terms as the dispute resolution, and hopefully we'll hear about that through the reporting as we go through and better understand the issues. Sarah, did you want to add your thoughts on that one?
I think so. I'm not 100% sure of the circumstances, but if you're a landowner and you've got an access arrangement in place, a voluntary access arrangement in place, that only applies to the extent that access is covered by that agreement. So if the transmission company is trying to undertake access beyond the terms of that agreement, then the transmission company has to comply with our statement of expectations. So I'm happy to follow up with that person. I'm not sure who it was, but you can give me a call if you want to talk through that.
Just checking that other people could hear that. I don't know if Sarah's sound was as disordered or is it just my end?
Can people hear
Probably
me?
just my end then.
John has a few sound issues, you might have realised.
Not to worry, Sarah, we can hear you.
Okay, maybe I'll take the next one given.
That is my sound issues because Alex is sounding exactly the same as Sarah is.
Right, okay, well, I'll take the next one, John, which is from Vicky, which is has AusNet developed a protocol and or template document for our review so that all landowners are dealt with equally. Vicky, we understand that AusNet is currently in the process of updating its landowner guide, and we're just awaiting an update from AusNet about when that will be released. If there's anyone from AusNet here who wants to address that, please just let us know. Do you want me to keep going, John, or are you back?
I've managed to fix my sound issue so I could hear you there.
Okay.
We're
up to Emma's.
The next question is from Barb, who's asked, the legality of entering property under Section 93 scenario relating to freehold land with no electricity easement, no consent, but landowner aware of Section 93 notice. Will it be lawful for a transmission entity to force entry, that is to break into property, e.g. cut locks, etc., when they're unable to contact the landowner? So that's a question about will someone be able to come onto land under a Section 93 notice when they're away from the property? And if you want to cover off the Section 93 rights, Sarah?
Yep, sure. So we are aware of this situation happening. So the transmission company would still need to go through all of the processes in the statement of expectations. So it doesn't matter where that landowner lives or whether or not they are familiar with the process. So if you just go, like, if you've got the statement of expectations in front of you, there would still be a requirement for the transmission company to be accessible, to employ two-way communication, to make genuine efforts to identify and contact the people affected. And we've spoken to the local councils, and we know that a number of local councils are willing to discuss getting the correct information for people so that people can be contacted. The transmission company would still need to explain the processes involved, be clear why access is required, give reasonable notice of proposed access. So all these things would have to be gone through before an access visit occurs. And then, of course, all the protections in Section 93 would continue to apply around minimising damage and compensation, and the complaint handling and dispute resolution processes would still be available. So where are we up to?
So I think there's a couple of other questions there. One is around the role of the Minister for Planning in the Code of Practice. So the Minister for Planning doesn't have a formal role in relation to this Code of Practice. This sits under the ESC as an independent regulator, so we make that code ourselves. So we're not subject to direction from any minister in relation to it, but we do consult with all the relevant government departments around. They're kept informed about what we're doing, as are relevant ministers. If there's any interaction with any of those other processes, then we would hopefully hear about that through that engagement. I think that's a reasonable answer, Sarah.
Yeah, I think that's right, Alan, and happy to discuss it more with you. I know that there are a lot of issues that are interrelated for people living on the proposed transmission line, and obviously concerns about the project itself over and above concerns about the land access process. The issues, as we've found, go hand in hand. But I do want to stress that really us as a regulator, we're regulating the land access process. So decisions around the environmental effect statement are really quite separate. And yeah, as you said, that's really not a role for us. And then in terms of your question about why does the Code of Practice have a mid-2023 issue date, too far out? Look, I hear you. I know if we could have implemented it more quickly, that would have been fantastic. But the Code of Practice is a regulatory instrument, so it's enforceable, and a breach of it is subject to civil penalties, and in worst case scenario could lead to loss of a licence for AusNet. So it's a very serious regulatory instrument, and for something like that, it's incredibly important that we do a really broad consultation process, including looking at the costs of it, the benefits of it, and the proportionality, and that does take time. And that's really why we have this statement of expectations, which is this interim process to make sure there are protections in place while we're promulgating the regulatory code.
Yeah, so we've got a question, I think it's from Emma, about whether offering vouchers or money, compensation, I guess it is an example of $500 vouchers or $5,000 compensation, whether that's appropriate for AusNet to do in terms of reaching access agreements. Don't know if you've got thoughts about that one, Sarah.
Well, look, it's not illegal, and I think, we have heard concerns from landowners that they felt as though some sort of inducement. Look, I think really what we're saying is that any sort of monetary benefit that a transmission company will provide a farmer obviously will not substitute for the engagement that we are mandating in this statement of expectations. And really, we think that is so much more valuable than a sum of money. To be honest, it's the engagement, the respect, it's the forming of those relationships between the company and the landowner, and the change in culture for the company to see the landowners as partners. That's really where we're heading, and really our expectation is that the relationship will improve between the parties.
Yeah, thanks, Sarah. I think that's a really important point. It's less about questions of compensation. Obviously, people can enter into voluntary agreements with AusNet on terms that work for them, and that's a good thing. But obviously, the issues are more than just compensation. As Sarah's talking about, there's a whole range of issues that people are raising concerns about, and that's probably much more important than biosecurity kinds of issues. We've got a question from Frank, who's a sheep farmer, and he says, "I use all of my paddocks with animals on each paddock. How will they access my property while building these towers? While I am or not at my property, who is responsible for animals escaping and getting into the main road that runs next to my property?" Yeah. So look, under the maybe I'll hand over to Sarah, but broadly speaking, any damage caused associated with the Section 98, there's issues around compensation around that. But happy to add any comments that you might want to have, Sarah, about that issue. I think.
Yeah, look, we've heard
comes back to that importance of engaging with AusNet or the transmission company around the nature of your needs on the property. How you might be able to move the sheep temporarily to another paddock while they access, what your rules are, and making sure that the staff accessing really understand about closing the gates, which is what I was taught as a young man on my uncle's sheep farm, about how to do that without letting the sheep out and all of that stuff. But Sarah, you might want to add to it.
Yeah, thanks. And I think we have heard a lot of concerns about livestock and animals. And I think that the principles require AusNet. The first thing I'd say is AusNet or any electricity transmission company is required to give reasonable notice of proposed access. So they've really got to give you warning about when they're coming. And look, I hear you. If you're saying it's never going to be suitable, never going to be appropriate, then I really think that if you can have those discussions with AusNet, and I know that it's hard at the moment, but if the relationship improves, to have the discussions with AusNet. I know there are people within AusNet who are thinking about these issues, and where appropriate, they are hiring contractors and experts to come and help them. So I think it's really about talking through your individual concerns, and ensuring that the AusNet people that come out are appropriately trained, and we're really here to make sure that process works.
So we have a question here about asking about clarity about which staff of which organisation have the right to issue authorised Section 93 powers. And this is someone indicating that Chad Hamill has been citing the authorities and just raising some questions about who Chad works for. Do you want to provide a bit of explain on that one a bit, Sarah?
Yeah, I'm very happy to. And I've spoken to many of you in this room about this. This went to the confusion and concerns early on about who was actually carrying out this process. Was it Mondo or AusNet? And of course, many landowners are very aware that it is AusNet who is licensed by the ESC to be an electricity transmission company, and it's only AusNet that is able to use those powers. So look, we took those concerns really seriously, and we sought information from AusNet firstly, and then from AEMO about who entered into the contract to build the relevant contracts to build the Western Victorian Transmission Network project, and we received confirmation that it is AusNet, and we have published that letter on our website, and I'm hoping that will help with some of the concerns from landowners. In terms of actually Chad himself. I believe he does work for AusNet Transmission, but if, Catherine, if you want to talk to me, I mean, there is actually a provision in Section 93 that allows AusNet to delegate these powers to appropriate people, and I think Chad is an appropriate person to delegate it to. But I'm happy to talk to you, Catherine, if you're still concerned about it. And I think, look, even AusNet accepts it was confusing, and they